to talk a little bit about Brazilian internet regulation, and I divided my presentation into two parts. In the first part, I will talk about Brazilian law, how it was created, and what Brazilian law says concerning freedom of expression, because this is the main topic of my speech today. On the second part, I will bring to you some important issues that are under huge discussion in Brazil, because these are kind of controversial issues, and there are four that I would like to mention to you. We don't have final answers regarding these issues. They are in the middle of this discussion. So, in the first part of the law, the second part, some important issues now. I'll start with the first part, and this is one of the persons who were responsible for Brazilian internet governance law or regulation law being adopted. Her name is Daniela Cicarelli. As you can see, she's a beautiful woman. She was a top model in Brazil. She had a TV show. She presented a TV show. And in the year 2006, more 2006 or 2007, she got married to Ronaldo, who was a very famous Brazilian soccer player. And they were married for some months, but the marriage was, everybody talked about this marriage, it was very famous by the time. But right after they split, because they divorced some months later, she was, in September 2006, in a beach in the south of Spain with her new boyfriend. And I'm telling you this story because Ronaldo was a football player, not only a Brazilian football player famous for playing for a Brazilian team, but he also played in Spain. So he was very famous in Spain. And when he got married to Daniela, he was playing there. And this is natural. That's why she was a known person there. Not only because she was a Brazilian top model, but because she was a Brazilian top model who had been married to a famous Brazilian soccer player who played in Spain by that time. So they divorced, and in 2006 she was in the south of Spain with her new boyfriend called Renato Mauzoni, if I'm not mistaken. And they were in a public beach during summer, hot day. You know, it was perhaps too hot, and they were very close, perhaps too close, and they obviously had some intimate moments on the beach. The problem is that it was a public beach during a sunny day with lots of people around them, and there was a guy, a Spanish guy, who recorded secretly these intimate moments. Right after, these moments became a video, and the video was suddenly everywhere. These were the three main websites in Brazil in which you could find the video. Of course, Daniela Cicarelli was not happy at all with this exposure. Although it was in a public beach, a sunny day, lots of people around her, she had not consented with her privacy to become a video. We must remember that this is 2006 or 2007. YouTube was something very new by that time. We didn't have the broadband we have now. And in Brazil, for example, even street vendors were selling the video, the recording on the streets, because people wanted to watch the video, but many people didn't have access to internet. And I'm telling you just to give you an idea of the dimension it took, this video took. But Daniela Cicarelli obviously was not happy, and she decided to sue Google because of YouTube. She sued and she requested the video to be removed, taken down from YouTube. The first judge to decide said, no way, the video is there because it was your fault. You were there in a public beach and you decided to have these intimate moments. It's your problem? No. But then she appealed to the second court, and the judge of the second court decided in her favor, saying, yes, of course, you're a public person, you are famous, you are married to Ronaldo, but it doesn't mean that you have no privacy. You have some privacy. So I decide that Google and YouTube should take down the video. The video was taken down. However, as you can imagine, 5 minutes later, somebody uploaded the video again. And then it was removed a second time, but 5 minutes later, it was there again. And then Daniela Scarelli got sick of this taking down the same video, and she requested the judge to take the whole website down. Like, look, YouTube cannot remove the video for good, so now what about taking the whole website down from Brazilian internet? And the judge thought it was a very good idea, why not? And YouTube was taken down. So for about 2 days, especially in the south of Brazil, nobody could have access to YouTube because of a judicial decision. Naturally, this was a mess in Brazil because civil society started complaining, everybody started complaining. There is no, it's not reasonable to take down the whole website just because of one video. The judge annulled his own decision. He decided the other way. He said, okay, this is not what I meant. It was. If you read the decision, you clearly see it was. But he decided differently 2 days later, saying, no, this is not what I meant, so YouTube can again be accessible in Brazilian internet. But then, at that moment, we noticed in Brazil that we had a huge problem. A problem of instability. We didn't know if, first of all, if a judge could decide that a website should be taken down, and second, who would be liable for the video being uploaded? Was the Spanish guy who first had the recording? It was the users who uploaded the video again and again? Was it YouTube who couldn't remove the video forever from its archives? At the moment that this is happening, this man was, by the time, a senator, and he had a bill of law according to which many of the things you would do in Brazilian internet would take you to jail. For example, if you downloaded music, or even if you unblocked anybody else's mobile, you would have to go to jail for 4 years. And believe me, you don't want to spend 4 years in a Brazilian jail, not even 4 days. And this was the first bill of law to regulate Brazilian law. So we started thinking, we don't need a penal, a criminal law. We need a civil law to regulate internet, because as you all know, the criminal law is the last step. When nothing else works, you go to criminal law. But if we don't even know who is liable for uploading a video to YouTube, how can we send somebody to jail? And then we started this huge movement to create a Brazilian civil law to regulate Brazilian internet. We call this law Marco Civil. It's the civil framework for Brazilian internet. And by the time I was at another institution, a different institution from where I'm now, and we we, with the partnership of the Ministry of Justice, we launched a platform in which people could discuss the creation of this law. We wanted to use the concept of direct democracy to create this law. And we have this in our constitution, but what our constitution says is that you can have public proposals of law, but to submit to Congress a public proposal, you need the signature of 1% of all voters in Brazil, which is more than 1 million signatures, from at least 5 different states, representing at least 0.3% of voters of each state. It's not easy, it's not simple, and this is the reason why less than 10 laws were submitted under this procedure to Brazilian Congress since the Constitution is in force, which means in the last 28 years, less than 10 laws were taken to Congress this way. So we didn't want this because it wouldn't work the way we thought was the best way. We also had in our, this is so unbelievable what I'm going to tell you, at least I think it's unbelievable. We had in our constitution from 1988 a decision, it's written there, that in 1993 Brazil should decide by public voting if Brazil would be a republic or a monarchy, and if we would have a president or a prime minister. Fortunately, we voted for being a republic with a president, but now we could be a monarchy, which makes no sense from the historical perspective of Brazil. However, it was a public decision taken in 1993, much before the world gone completely crazy as it is now. If this decision were taken now, I have no idea what would happen. Perhaps we would become a monarchy, I don't know. But although we have this tradition of deciding with collaboration of direct democracy, none of this represented the idea we wanted to share with people of creating a law for internet. So in 2009, we launched this project on a platform called Marco Civil da Internet, the Internet Civil Framework. And in the first phase, the law was discussed in 2 phases. In the first phase, the discussion concerned some topics. For example, privacy, freedom of expression, right of access, liabilities, net neutrality, and governmental data. These were the topics. So the questions were like, do you think anonymity should be allowed? Who should be liable for content posted on the internet? Should be the website? Should be only the person who makes the upload? Both. Who has the right to remove the content? A judge or the website owner? So in the first phase, only these topics were under discussion. There were questions, and everybody from Brazil, and even outside Brazil, could contribute answering these questions. On the second phase, we had no more the questions, but we had the draft of a bill. The Ministry of Justice collected all the answers from the first phase, and then they created a draft of the bill, and the draft of the bill was submitted for the second phase. So people no longer discussed principles, people discussed writing. And this is confusing, this is not the best way to address this or that topic, so people started discussing how the law should be written. Here we have some comments, and we accepted comments from not only Brazil, but from abroad, and not only from the own platform, but Twitter and Facebook and anywhere. There were 3 very controversial issues, and they were, freedom of expression, of course, who is responsible for the content, who is liable, and who decides if the content should be kept or removed. Net neutrality, which was probably the most controversial of the issues, and data protection. Data protection is still a problem in Brazil because we don't have a data protection law. For several years we've been discussing the draft of a bill, but we still don't have it, and with the current Congress, National Congress we have in Brazil, we'd better not have a data protection law. I hope we only have a data protection law after the next election in 2018, because with the Congress we have now, we'll probably have the worst data protection law conceivable. The project, the voting of Marco Civil was postponed 29 times in Congress, mainly because of net neutrality, because nobody could agree to the terms of net neutrality. But finally, fortunately, on March 25th, 2014, the law finally passed, and it passed, I believe, because of two reasons. First, because of Edward Snowden, because of everything he had mentioned right before. Second, because Brazil was hosting, at that moment, an international event called Net Mundial. And it would be a shame if the then President Dilma Rousseff, who had been spied by American government, by NSA, didn't approve, didn't sign a law regulating Brazilian internet after everything that Edward Snowden had said. This is the reasons, in practical terms, why Marco Civil was approved that moment. Marco Civil, I'm not going to show you many articles. The law has 32 articles, and it's not my intention here. But I would like to mention only the structure of the law and show you the two articles concerning freedom of expression. This law is full of principles, and this is the way we've been doing law, making laws in Brazil. Full of principles because the laws in this way are more flexible, and as time goes by, you don't get old laws that cannot be used anymore. Principles give more flexibility. So, as you can see, Marco Civil in the first article talks about principles, the second mentions freedom of expression, human rights, diversity, social purpose of internet. Third article, more principles, freedom of expression, privacy, data protection, and neutrality. 4, objectives of internet such as right to access. 6, economic, social, and cultural importance of the internet. 7, rights, private life, data protection, clear information about the data use, and finally privacy. So the first 8 articles are principiologic articles, and in some of them you can find a clear reference to freedom of expression. Of course, we have the freedom of expression in our laws, not only in Marco Civil. We have it in our constitution, the Brazilian constitution, the 1988 constitution, in its article 5, which is the most important article because it's the article that protects the individual liberties, is an article that mentions with all the words and all letters that the freedom of expression is a right protected under the constitutional values. But also, Marco Civil has this protection of freedom of expression concerning the internet. Probably the greatest discussion while we were talking about the writing of the law was who would be responsible for removing the content. The first draft stated that if you know the system of notice and takedown, right? And notice and notice. The first idea was Brazil to adopt a system of notice and takedown. So if, by any reason, I think there is a content that violates some of my rights, I would write a notice to the website saying, look, here there is a content that violates my privacy or my honor, and I want you to remove. If the website didn't remove the content within, let's say, 48 hours, the website would become liable for keeping the content there. This was the first idea. But this idea has a great disadvantage. It leads to private censorship. Because if I just don't like the owner of the website or the person who made the post, I simply notify the website saying, this violates my honor or anything, and even if it doesn't, the website will probably remove the content because this website will not be wanted to be considered liable for keeping the content there. So many people from civil society said, no, this is not right, this is not fair. Only a judge can decide if the content is violating somebody else's right or not. Well, but this takes to another problem. Brazilian judges have many more processes to decide than they can. So it will take much longer for them to tell a website to remove the content than a simply private notification. Well, the end of the story is that the judicial order to remove content prevailed. So this is what Brazilian law says. Only a judge can determine if a content should or should not be taken from a website, from the internet. This is what says Article 19. In order to ensure freedom of expression and to prevent censorship, you see, to prevent censorship, internet application providers may only be held civilly liable for damage resulting from content generated by third parties if, after a specific judicial order, the provider fails to take action to make the content identified as offensive unavailable on its service by the stipulated deadline, subject to the technical limitations of its service and any legal provisions to the contrary. So only judicial orders can, only if a judicial order is not accepted by a website, this website will be considered liable if it keeps the content there. But we have two exceptions here. The first exception is, out of curiosity, is copyright. This is not the rule for copyright. Paragraph 2 says, this article will apply to violations of copyright and related rights only when specific legislation to that effect is adopted. Why? Because Brazil has a copyright law, of course, from 1998. This is an outdated copyright law, and for several years, from 2007 until 2011 or 12, we discussed a huge reform in our copyright law. However, President Lula had his term ended, it was the end of his term. He was replaced by President Dilma Rousseff, his successor, whom he helped to elect, but President Dilma Rousseff appointed as the Minister of Culture a person who didn't want to make this huge reform in the copyright law. So the reform never happened. But Marco Civil was written the same moment everybody was expecting to have a reform in the copyright law. So the copyright law would be the place in which we would decide what would be the liability rule for copyright. The problem is now we don't have a new copyright law and we don't have a rule for copyright. So there is a highly insecure area in Brazilian internet regarding liability, and this area is the copyright. Second exception is Article 21. Internet application providers that make available content created by third parties will be secondarily liable for violations of privacy resulting from the disclosure without the participant's authorization of images, videos, and other material containing nudity or sexual acts of a private nature if after receiving notice from the participant or the participant's legal representative, the internet application provider fails to take prompt action to remove the content from its service subject to technical limitations of the service. Why? Because we thought that the so-called porn revenge would need much faster response from the judiciary than regular, normal liability issues. That's why the law decided that if it is a matter, and basically because there is no public interest in seeing naked people. This is something that concerns only the involved people. There is no, in rule, as a general rule, there is no public interest in keeping that material in the internet, and that's why the law makes this second exception. If it refers to nudity or sexual private acts, then a mere notification, private notification, is enough to make the website liable if the website does not remove the content from the internet. So the rule we have regarding freedom of expression in Brazil in the internet is removal by court order. However, we have two exceptions. Revenge porn, so it's only notice and take down, and copyright, which we don't know exactly what the rule is. Each judge decides his or her own way. Something very important to mention before I go to my second part is that a website is not prohibited to remove content. If I notify a website and say, look, this content violates my honor, the website is free to remove the content. But the website will be liable for not removing only after a court order. But it doesn't mean that the website can remove the content only after a court order. It can remove the content anytime they want, but they will be considered liable only if a court order decides that that content should not be there. So this is my first part to explain you how the rule regarding freedom of expression in Brazil is written in the law. In my second part, I would like to comment I could choose several topics, but 4 topics that are being regarded as more important now in Brazil. Blocking content from internet, the right to be forgotten, unauthorized biographies, and who has the power to decide. I'll begin with the blocking the content. WhatsApp is an app very important in Brazil because sending text messages in Brazil is extremely expensive. I don't know what about Quebec. I don't know if here you would have to pay to send text messages, but in Brazil it's very expensive. That's why many people use the internet to send text messages. And WhatsApp is the most popular app for this purpose. We believe that over 100 million of Brazilian people use WhatsApp, which would be more than half population. More than 50% of Brazilian population use WhatsApp. The problem is that many times, like everywhere, not only in Brazil, WhatsApp is used for criminal purposes. And because of investigations of pedophilia, drug dealing, terrorism, you name it. Judges request personal information from WhatsApp. But WhatsApp uses a cryptography technique that prevents WhatsApp from keeping the content. They don't have the content in their servers. They don't keep anybody's content. They can have access, of course, to the name of the user or to the number of the mobile, but they don't store the content of the messages. What Brazilian judges are doing? They request data, WhatsApp denies, and the Brazilian judge says, so let's block. The judge writes a court order, sends to the main telcos in Brazil, saying, you must block WhatsApp now. And this is the reason why WhatsApp was blocked in February 2015, and again December 15, and again July 2016. At least 3 times. And at this moment, many bills of laws are being discussed in Brazil to create a mechanism to allow legally applications from the internet to be legally blocked. And this is completely absurd from any point of view. It's completely absurd. But there are some initiatives from our Congress to create such laws to allow the blocking of apps. I remember in December 2015, I was in China. I had been invited to go to China for a WIPO presentation, the World Intellectual Property Organization. And in China, Gmail doesn't work, Google doesn't work, and Facebook doesn't work. They are both blocked in China. And I was there only for 4 days, but I was very happy because I could communicate with my family via WhatsApp. Only the first day, because on the second day WhatsApp was blocked, and you have in Brazil, and you have no idea what it is to wake up in a country like China. I don't speak the language, everything is very different. You were 12 hours in a difference from your country, and the only way you had to communicate, you no longer have, because your country blocked the only app that worked there. It was only for 1 day, but yet. And many people work with WhatsApp, so only very authoritarian countries block the applications in the technical system of the internet, not in the content level, but in the infrastructure level. And Brazil is becoming one of these countries. And why it's being blocked? Because one article of our law is leading judges to misread the article and misunderstand the article, and this is the reason why they are allowing WhatsApp to be blocked. The problem is this article, it's not 11, it's the 12, but the 11 says, all operations involving the collection, storage, retention, or processing of records, personal data, or communications by internet service and applications providers must comply with Brazilian law and the rights to privacy, protection of personal data, and confidentiality of private communications and records if any of those acts occurs in Brazilian territory. All operations involving collection, storage, retention, or processing of records, personal data, or communications. The following article, 12, says, in addition to any civil, criminal, or administrative sanctions that may apply any infraction of the rules under Articles 10 and 12 is subject to the following sanctions, applied singly or in conjunction according to each case. You can see number 3, temporary suspension of activities that involve the acts referred to Article 11. So the temporary suspension is not of the application, is of the activities. Which activities? The collection, storage, retention, or processing of records, personal data, or communications. It's not the app itself. It's one of these operations that can be suspended. And why should I suspend one of these operations? Because many apps earn money selling data. And if I prevent them, prohibit them to collect the information, they will not be able to sell data, for example. But this is the misunderstanding that is taking WhatsApp and other apps to be blocked in Brazil. Second, I would like to talk a little bit about the right to be forgotten. As you know, this is an issue that has arisen because of a Spanish decision in the European court, because of a guy who wanted to be delinked. He didn't want, a Spanish guy who didn't want his name to be found in Google. This is something very old. This doesn't exist anymore. But when I went to the cinemas when I was very young, I saw this chart. And you can see there on the 3rd line, it's written, Division of Censorship of Public Entertainment. So Brazil had an official organ called Division of Censorship. And nobody was ashamed of that. It was the Division of Censorship. And the Division of Censorship was responsible for saying, well, this movie can be watched by this person or that person. And in this case, this movie was allowed only for people over 18 because of scenes of sex, you can see there. This is a classic movie in Brazil. Well, so we had censorship. But to what extent the right to be forgotten is not a censorship? Let's see. This is a very famous Brazilian presenter. Her name is Maria da Graça Meneghel, but she's known as Xuxa. This is her name, her social name for entertainment purposes. She's around 50-something nowadays. She's a very beautiful woman. And many years ago, she presented TV programs for children. She was very famous for that. This is the way she dressed 30 years ago. This is the way she dressed 30 years ago in her TV show. Sometimes she also dressed this way. As you can see, this was 1980-something, the crazy 80s in which a TV presenter could be dressed this way to present a TV program for children. As you can see, many children around her. But a little before that, in 1981, she made a movie called Amor Estranho Amor, Love, Strange Love. She was 18 by the time, 18 or 19. It was the beginning of the 80s. And in this movie, she performed a woman who had sex with a 12-year-old boy. And you could see the scenes. It was not a pornographic movie in the sense that there was no explicit scenes, but you could clearly see Xuxa naked with the boy naked by her, or with her, on the bed. This is Xuxa promoting the film when the movie opened in cinemas. And this is one of the posters of the movie. The problem is that some years later, the movie was released in video cassette. And she was already, by the time, the presenter of TV programs for children. And naturally, she didn't want children to see the movie in which she had performed those scenes. So she requested the movie to be collected from the stores. And the judge said she was right, so the movie was collected from everywhere. This is probably the first and the most famous case in Brazil regarding the right to be forgotten, much before internet. We're talking about the 80s. And for many years, nobody could watch the movie because nobody could find it. But now, if you go to the internet, of course you can find it again. And Xuxa has been struggling since then against the movie and against her pictures, because she was a model and she also took pictures naked to magazines. And those pictures are everywhere. And she's been struggling to remove this content from the internet, or not allowing people to make reference to the film that in which she performed, or the pictures that she took. Now we have two major cases discussing the right to be forgotten. They are not regarding internet, but they will reflect in the near future decisions regarding internet. This is a TV program that reenacted old famous criminal cases in Brazil. So one of the criminal cases was this one. It was in Rio de Janeiro. Several children, homeless children, were murdered, executed in one night in 1993, if I'm not mistaken. Some years later, the TV channel decided to reenact this terrible killing of, I don't know if you Brazilians remember, but it was about 20 children that were murdered at once. And the TV channel reenacted this episode and made reference to a man who was considered a suspect. However, the man who had been considered a suspect 15 years before, he was considered not guilty. And when 15 years later somebody made reference to his name, he again was involved in this situation, in his work and in his family and everything. So he sued the TV channel requesting some compensation for his exposure. And he won, because the higher court said that the TV channel could tell the same story without mentioning his name. It was not fundamental, it was not necessary. So there was not a limitation in the freedom of expression. You could express yourself, you could retell the story, but it was not necessary to make reference to his name. The second case, same program, same TV channel, reenacting, retelling the story of this woman. She was 18 years old by the time. She was murdered by her boyfriend. And it was in the 50s or 60s. So 50 years later, the TV channel retold the story, and her brothers sued the TV channel saying, when you retell the story, I suffer again everything. It's painful for us. So they sued the TV channel, but the TV channel won. For the same reason, in fact, because this story could not be told without mentioning the name of the victim. Her name is Aida Cury. The case is known in Brazil as the case Aida Cury. This is a famous case, and the case is famous with her name. So there is no way to retell the story without making reference to the victim's name. The Supreme Court in Brazil is about to decide if these decisions were right or wrong. And the decision of the Supreme Court will, I have no doubt about that, will influence the next decisions when we have to decide something regarding internet. non-authorized biographies. Until last year, non-authorized biographies in Brazil were illegal. You could not write biographies without the permission of the person who is the object of the biography. But if you consent that somebody else is write your biography, it's not a biography. This is marketing, personal marketing, because the person will only say good things about you, because you will only allow people to say good things about you. But last year, our Supreme Court decided that non-authorized biographies were legal. This is a very famous case. This man is probably the most famous Brazilian singer. He's around 70 or 70-something years old now. And he did everything he could to prohibit, to forbid this book to be sold. In fact, he managed to collect all the book, and the book said nothing bad about him. It was a book written by a fan, saying the best things about the singer, and nevertheless, he didn't want this biography to be sold. And also this other biography of another Brazilian soccer player, very famous Brazilian soccer player from the 50s, and he was already dead. His daughters sued the writer and the publishing company because they said the book was telling too many personal details about the player's personal life, including his sexual life, etc. So we still have to see how judicial decisions are going to be, but until last year, non-authorized biographies was a problem in Brazil regarding freedom of expression. And I'll finish here with my last topic, and the topic is who decides? Who decides what can be published or not? What should be removed or not? We know that we have that rule, the Marco Civil rule, but it refers to liability. And what I'm going to talk about is not liability, is making decisions. For example, this is a picture that was published on Facebook by Brazilian Ministry of Culture. And Facebook removed the picture because you can see a naked indigenous woman, like we have in Brazil. This is our original population. But Facebook considered the picture to be indecent. The Minister of Justice of Culture was not happy at all with Facebook, and we had a small diplomatic incident between Facebook and the Ministry of Culture, so Facebook decided to put the picture again there. But this is not an isolated case. You probably remember this painting. This is a very famous painting. It's a 19th century painting, and the painting is au Musée d'Orsay, here in France. It's a famous painting. However, Facebook removed the painting, and I think in France it was even worse, because as you can see here, l'origine du monde, le nom de la peinture, c'est l'origine du monde, et c'est un nom excellent. Facebook ne pourra pas échapper aux juges français. Ça veut dire, in France, they decided that Facebook has to answer to French judges. But how can you make this decision enforceable? This is the most difficult. We have a huge problem of jurisdiction in the world, because we have these companies that are everywhere. But how do you make the decisions enforceable? This is not very easy. In Brazil, last year, the same picture was, the painting, was on the cover of this magazine, that was sold on the Sunday edition of the most important newspaper in Brazil, that everybody buys, not in Brazil, but in Rio, that everybody buys. So, a picture that cannot be shown on Facebook was on the cover of a magazine that everybody can buy. And finally, this is from last week. This is also the cover of a magazine. This time of a magazine in the Sunday edition of a newspaper in São Paulo. And you can see she's an actress, she's an old actress, she's over 80 something, but she's still playing on the theater, she's still working in plays and movies. And the picture was on the cover of the magazine, and the magazine published its cover in Instagram, and Instagram removed the picture, saying that it was indecent to have this woman with the breasts naked, and it wouldn't allow this picture to be there. Even after many people complaining, as far as I know, Instagram kept its decision of removing the picture. So, if I'm not mistaken, it was Bauman who said, when we had to deal with the state, perhaps we were not very happy to deal with the state, but we knew the rules, and we knew where to go to complain or to ask for a change of the rule or for a judicial decision. But now we don't have state and power with the same entity. We have the state, but the power not always is with the state. The power, and the power of communication, the power of this mass communication, such as Facebook and Instagram, the power is not with the government. So what are the rules they follow, or what are the rules we should follow? And this is making the freedom of expression more complex, not only in Brazil, but everywhere. Because freedom of expression has also to do with time, with space, with morality. We all live in the same time. Not everybody lives in the same space, but we definitely live under different morality rules. So how can Facebook or Instagram or any other player who is everywhere determine what is freedom of expression to each state, and how are we going to deal with this challenge in the future? So these are some of the things I would like to tell you. I hope I didn't talk too much, but I love talking about that, so sometimes I talk too much. And I'm here at your disposal in case you want to make any questions or comments. And thank you again, Karim, for introducing me and for staying here until now. Thank you very much.
Alors effectivement, période de questions, si quelqu'un veut se lancer, moi je vais me lancer.